So two major cases challenging rifle bans and magazine bans just went in front of the Supreme Court once again. And these cases are not alone. Multiple other rifle and magazine ban challenges lined up for that exact same conference, and they have now been relisted once again altogether. So let's break down what is happening and why these cases are pushing for the Supreme Court to finally answer a very simple question. Are AR-15s and magazines protected by the Second Amendment? Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the like button that just tells the algorithm that you appreciate this content, and so it shares it to you and more people as well. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to give you as much as possible, as you get your benefits as a member. And one of the new things that they just announced at their conference is the Hero Clause, which allows you to get protection even if maybe you're not tried for self-defense, but maybe you fall under a regulatory issue. They now have a Hero Clause, which can also be part of your benefits. So if you're interested, if you want to learn more, you can click the link down below. And if you use my code ARMSCHOLAR, you can get $25 off of your sign-up plan. So if you've been following the channel for a while, you will know that the Supreme Court has been avoiding the rifle and magazine ban issue for many years. And the core question really in all of these cases is very simple. Does the Second Amendment protect common semi-automatic rifles like AR-15s and then also standard capacity magazines? Now, on this topic, lower courts are deeply divided. Some say that these items are protected arms. Others say that they are too militaristic, that they are useful in military service, and therefore do not have two-way protections. And some say that they can still be banned even though they are protected under the Second Amendment. And that confusion is exactly what these cases are now asking for the Supreme Court to fix and resolve. Well, now multiple rifle and magazine ban cases went to the Supreme Court at the same conference last week. And on this week's order list, the cases were not denied, but now once again, they have been relisted all together for the same conference at the end of this week on Friday for February 27th. So once again, all of these cases are going to go to conference. So we need to talk about what this may signal for these cases going forward. Now, the two main cases that I want to focus on are Vermontes and Duncan. Now, the first key case is Vermontes versus Cook County. That case challenges Cook County's ban on so-called assault weapons, which include things like AR-15s and then also dozens of other commonly owned rifles. Now, the plaintiffs in this case argue that these rifles are in common use and therefore protected under Heller, Bruin, and the Second Amendment. They are asking for the Supreme Court to finally say once and for all that states, counties, and cities cannot ban an entire class of commonly owned rifles. The second key case is Duncan versus Bonta, and that one deals with California's ban on magazines. This is a case that previously already went to the Supreme Court. It was granted, vacated, and remanded by the Supreme Court after Bruin, but now it's back in front of the court once again because the lower court, specifically the Ninth Circuit, continues to uphold these magazine bans despite that Bruin framework. Now, here's what's important for these cases, and here's now what is happening. Both the Vermontes and Duncan cases have been relisted once again instead of being denied. So I guess that is a silver lining where these cases were just not simply outright denied on this recent order list. That means that the Supreme Court justices maybe are actively discussing them behind closed doors. And recently the court relisted them to go to the same conference along with multiple other rifle and magazine ban cases. That means that they are not just simply alone, they are grouped together with other rifle and magazine ban cases. So there is now kind of this group of issues and cases dealing with rifle bans and magazine bans that were at conference and now have been relisted once again. That creates something that we have not seen yet, which is multiple cases on the same constitutional question landing together once again in front of the Supreme Court. Now, this is maybe what many of the Supreme Court justices have been suggesting that they've been wanting for a long time. Instead of taking one isolated case, maybe from one state or one circuit court, the court can look at multiple bans, multiple circuits, multiple conflicting rulings all at once, and that allows the court to resolve this issue nationally instead of just doing a piecemeal decision. It can also help to avoid this criticism maybe with some of these cases where maybe a case is a wrong vehicle because they have multiple cases, they can kind of address that issue. This is now shaping up as a coordinated movement where the court can finally answer, are AR-15s protected arms? Are magazine bans constitutional or unconstitutional? And can states ban common firearms? However, like I mentioned, these cases have once again been relisted for another conference on February 27th, so at the end of this week. That means now that the Duncan case has been relisted 7 times, and then now also Viramontes has been relisted 6 times. Now, here's why relists are so important and something that we need to keep our eyes on, because it is simply just not something random. Historically, cases that are relisted at least once have a much higher chance of being granted review, but cases that are relisted many times can kind of go either way. Sometimes multiple relists means that a denial is coming. Maybe simply the relists are stacking up because there are some dissents that are being written in that denial. But sometimes it also means that the court is lining up cases together for a coordinated grant. That makes, what is happening right now so important and so critical for us to watch. It may not be that, they're just interested in Viramontes or Duncan. It may be, them grouping all of these rifle and magazine ban cases together, and then maybe they're deciding what they want to do. Also, multiple relists does not always mean that a case is going to be denied and maybe that a denial is coming. In a lot of the very big two-way cases that we got, like Bruin, Cargill, and Caetano, those cases were relisted, multiple times, some over, 10 plus times, 14 plus times before they were granted review by the Supreme Court and then decided. So where does this currently leave us? Well, we now have the Viramontes and Duncan case once again being relisted and going to conference this Friday on February 27th, along with multiple other rifle and magazine ban cases. This again creates the perfect storm of cases all focused on the same constitutional question. And if the court grants even one of those cases, or maybe several of those cases altogether, we may finally get a definitive ruling on rifle bans and magazine bans nationwide. And after years of delay, this could be the moment that the court can no longer avoid this issue. So now we will be watching the order list once again, next week on Monday, after this conference to see what happens. There are a lot of options right now that the Supreme Court has, especially something that we need to watch for after this, upcoming conference. Best case scenario is one of the rifle or magazine ban cases is granted review. Really, if all of them were granted review, that would be the, hyper best, case scenario where all these cases are granted review and considered all together. Worst case scenario is that all the cases are denied on the order list. And if that happens, it would just show that the Supreme Court is still unwilling to review this issue and not that concerned about fulfilling that promise that they made, last term, which is that they would address this rifle ban issue in a term or two. There's also the option that the court is just simply pushing these cases, kind of using it as a placeholder to push these cases going forward. Maybe they want to grant review to this case in the late term here, and then argue the case and have the arguments in this case next term. So maybe they're just using the relist as a placeholder to push this case out even further so that it's addressed not this term, but next term. So again, we will be watching this court closely to see what happens after the conference. So that's where things currently stand right now in the critical rifle and magazine ban cases that are in front of the Supreme Court. As soon as we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of two-way content, and so it shares it to more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.